made or seen. And yes, I realize that we just started broadcasting. I hope the court will let me keep going where I'm at.
Yes, go ahead.
And there is no statement that a threat has been made using the mom's phone to the other person, the purported boyfriend, that someone else has been seen. In fact, though that's impossible because if we believe the text messages on their face, as does the officer, it went to the mother, it didn't go to the boyfriend. So there was no threat made to him. If we believe the testimony about the statement made to the new boyfriend from over a year ago, that is now being brought for judge. There's nothing to say that anyone has witnessed this defendant actually making any threats. What we've got here are communications from a number going being delivered to the officer via email, but nothing else about it, their origin. And so I'm going to ask the court at this point in time to dismiss all of these charges as insufficient probable cause. Thank you.
Thank you. All right. Go ahead, ADA Thomas.
Yes, ma'am. I'm going to start with the statute that the officer used, which is the terroristic threats. Your Honor, two things regarding defense counsel's argument. He is contending that it has to be done in person. I've been reading through it over and over again while this hearing has been going on, and I don't see not one word regarding an in-person component of a threat. Further, in the case notes that I'm seeing in my reference materials, Your Honor, there is actually a case where the defendant told his girlfriend over the phone he communicated his threat. And that is under terroristic threats, not harassing phone calls. The court found the conviction in that particular case proper. The case site would be Crawford versus the state, 318 Georgia App 270-732 Southeast 2nd, 794. And that's a 2012 case, Your Honor. Another case that is cited specifically mentions the fact that it has to be communicated. It doesn't require how. There's no mention of how the threat has to be communicated. And I believe the defense counsel has also made an argument regarding a threat to the child. Your Honor, a threat can be made to a specific person. It can be made to the household of a person who is being threatened. This child, per the victim, is a child that she shares with the defendant, and there's no reason why anyone would be untruthful regarding that particular statement. The threat was directed to the household, and I believe that's why I know that is why I asked the officer to quote in her report what was presented to her, the section, when I come in that MF, I kill everybody. Just know it's your fault. That's your baby and the nigga, quoting him. I'ma kill all y'all.
Judge, I'm sorry. Objection. Facts not in evidence.
Oh, but they are, Your Honor. The
No,
officer.
Thomas, I agree that you made some statements that were not placed in evidence, but continue on. Go ahead and go.
I'm sorry, Your Honor, but I believe that's what I had the officer read into in her testimony when she referred to her report. And I stopped where she stopped because it goes on a little bit longer than that. And that indicates the intent to harm the persons in the household. And I also asked the officer, did Mr. Branch, the other adult victim, does he live there? And she indicated that he and the child live there. She was able to confirm that it is in fact a child under the age of 5, and she lives there with her mother and the mother's new boyfriend, Gregory Branch. So under the statute, as the officer has charged it, sufficient probable cause, where in this case, it normally would be a misdemeanor, but per this one statement, and there are a couple of others, he indicated he was going to kill the recipients of this. So state would contend that there is sufficient probable cause at this point to transfer all 3 counts of terroristic threats to the Superior Court of Clayton County.
All right. All right. So I only find probable cause for one of the warrants. The warrants really just recite the same thing, but I'm going to find probable cause against the mother, the mother of the child or the victim in this case, which is 2025 CW 70073. I am dismissing 7074 and 70075. That's the word of the court.
Thank you, Your Honor.
Thank you, Judge.